Thank you for everybody. Let me introduce my direction before you start. The purpose for this hearing is to go through the CMC procedure. I will give the chance to the claimant to speak or to present his position regarding to his application to amend the case, the statement of the case. And I will give another direction as I drafted in terms of the immediate judgment. Then I go through a procedures timetable for usual procedures to run any CFI cases. Any additional application, I'm not willing to deal with it today. It should be dealt with in a fresh application, either to the hearing judge or another judge, if the court allocated another judge for this case. So in this start, I may ask you to go through your presentation.
Yes.
And either you want to go through the first point regarding the amendment of the state or case statement, or you want to go through the timetable. It's up to you.
So far as the timetable is concerned,
Right.
I've had an opportunity to discuss matters with my friend Mr. Sethi,
Right.
and the parties are agreed to this extent, that this is not the run-of-the-mill case before the CFI. And in one sentence, we're agreed that no trial timetable should be set today, but I can explain why. Your Honour will have seen that there are claims and counterclaims concerning funding the defendant in this case. We say that the defendant is funding his defence with our money, the money that he stole from us. Disclosure must of course relate to the issues that are live at the trial. And Your Honour has seen that our immediate judgment application is for immediate judgment, or in the alternative to strike out a part of the defence. The parts of the defence which we seek to strike out in any event relate to the various allegations of institutionalised wrongdoing made by the defendant against my clients. On the claimant's behalf, we are concerned that if we are to succeed in immediate judgment, but in the interim continue to trial as if there would be an effective trial, there is a danger of a very significant sum of money being spent to no end. And in any event, it's difficult to identify the scope of appropriate disclosure until the question of whether the defendant should be permitted to make the allegations that he makes against my client, or whether they have anything to do with this case, has been resolved. The defendant, for his part, as I understand it, and Mr. Sethi will be able to speak for him in due course, feels that he has very constrained resources, very few resources available to him. And he probably would say that he doesn't have the funds to prepare for trial at the moment in any event. So, albeit for different reasons, we would invite Your Honour not to set a trial timetable to date, but to adjourn this case management conference to the hearing of our application for immediate judgment. So if that application fails, then once the scope of the issues in the case have been clarified by our alternative application, that we submit would be the appropriate time to make directions for trial.
Well, in other words, what's wrong with set for now procedure timetable, and that will be including your opportunity for filing the immediate judgment, and allocated judge will deal with that. And if that doesn't go through, you lose your application for that, then the rest of the procedures will continue. So I cannot see this option, which is the right option. This is the typical procedure for this court to deal with, to have a timetable schedule, and through that timetable you can submit any application you need. So give me a sufficient reasons why if the court today decides for a CMC order with a clear timetable for everybody, the typical timetable including the witness statement or any production of document, you might not agree in some allocated dates, but if we have that timetable, wouldn't it be more straightforward for this case to be proceed? Even in terms of cost. And is there any
but Your Honour has in mind, no doubt, that if a timetable is set, all of the parties know the timetable to which they must work, and the case can proceed, and there won't be perhaps a very long delay before the case comes to trial. The concern that I think there is on both sides is that whilst in the ordinary case that might be absolutely correct, in this particular case, because we would say the money is all coming from us in any event, because even the money the defendant spends on his defence is money that we say we are entitled to, and which was stolen from us, we're anxious that no more costs are incurred than are absolutely necessary. Now, if Your Honour is minded nevertheless to impose a timetable today, then I would urge Your Honour to make it a timetable which does not begin to bite until after the summary judgment, the immediate judgment application has been dealt with. In other words, that the time between the hearing of the immediate judgment application and the time for compliance with the various stages of the court process should be long enough that in effect the parties don't need to incur the costs of complying with that timetable until after the immediate judgment application has been disposed of.
I have no problem with re-change the time here, but as long as we agree in this as a principle to set up today a procedure step by step, then we can deal with the time. Especially I'm giving you a chance for my draft. Have you seen my draft?
I have indeed, I have it before.
I give a chance for the application for immediate judgment. So if the judge who's sitting in that, who will be looking to that application, he decide that, he need more time to deal with that application, that's it. But for this court, it's very rare that it's adjourning the CMC for immediate judgment to deal with this first, then they go,
yes.
Everything will be
I understand.
backwards. This is not even our KPI.
I understand that. The other reason for my caution in simply agreeing a timetable is that whilst Your Honour is absolutely correct, if I may say so, that we always have liberty to apply and that we can always come back to amend the timetable if necessary.
Sure.
I would not like, on behalf of the claimant, to agree a timetable which is likely to be varied inevitably.
Yes.
So that is why I say that perhaps the most convenient course would be to adjourn the trial management part of the CMC until after the until the hearing of the immediate judgment application. But if Your Honour is not with me about that, then I urge Your Honour to make directions which are sufficiently far ahead.
This is why I send in advance my draft, so you can, advise on the
Yes.
on the allocation of dates and month. So you can deal with
Perhaps
that.
whilst we have Your Honour's order before us, Your Honour has, as indicated, kindly provided directions for the hearing of the immediate judgment application,
Yes.
although not for the actual hearing of that application. Now, I understand that it's not possible at very short notice to simply provide a date at some point between March and April.
Mm-hmm.
But that, in my submission, the date on which the application is likely to be dealt with should be a very important date from which the trial timetable is dealt with, if Your Honour is with me.
Yes.
So I would urge Your Honour's
Yeah.
clerk, if she's able, to at least find a window for the hearing of the summary judgment application. I don't know whether the judge would wish to reserve judgment or wish to give it immediately.
Right.
It may be that he will be able to give judgment immediately but give reasons on a later date.
Right.
But if he wishes to give judgment immediately, it may take some time just to deliver the judgment, and he will no doubt wish to think about it. And for that reason, I would urge Your Honour to list the immediate judgment application for 2 days. Your Honour has seen that both Deputy Chief Justice Sir John Chadwick and Sir David Steele have had some detailed involvement in the
Yes.
case, and in my submission it would be appropriate that it's placed before one of them, which of course means that any window is
Right.
dependent on their diaries. I look to Your Honour's registrar. I don't know whether she would be able to consider that whilst we are speaking.
Yes. We can deal with this later on. I mean, we don't need to decide it
So,
right now. Yeah.
the second thing is that the timetable. Your Honour gives us until the 16th of February to lodge the application, and that's the date that was in my skeleton argument, which I hope Your Honour received.
Yes.
But Your Honour gives only 10 days to respond. Now, for our part, we are of course anxious to get this on as quickly as possible, and for our part we say the defendant is quite able to produce documents and evidence when it suits his purpose. But I know that my friend Mr. Sethi would wish to address Your Honour on that, and I would recognise that it is a tight timetable. The evidence is not going to expand beyond the evidence which the defendant and his legal representatives have already seen. There will be a need to adduce some further evidence before this court, because it's been adduced before courts in London and Guernsey. But the defendant has already seen it, so to that extent it's not that he will need a great deal of time to consider it. But I am anxious on behalf of my client that any timetable is a realistic timetable and one which the defendant can be held to. Because one of the difficulties in this case has been representations that we went to see the defendant in prison, but we were only allowed to speak to him for 5 minutes, or the guards wouldn't let us speak to him that day, and so on.
Yes.
Maybe Mr. Sethi can assist you on in more detail. We asked for a robust timetable, but I have to recognise that 10 days may be ambitious.
As I said, I'm happy to change those days for your convenience and the defendant's convenience. So I don't have a problem with that.
Yeah. And if, when a date can be found, to dispose of the immediate judgment application, Your Honour will be minded to push back the timetable beginning at paragraph 6 of Your Honour's order.
Yes.
So that perhaps it,
Push maybe to May or?
for example,
Yes.
depending on the date for the hearing,
Right.
May or June, perhaps with a view to a trial in the autumn.
Yes.
I should also say that it's unlikely that 3 days would be sufficient for this trial.
Yes.
Your Honour, with those remarks about timetable, I make an application to amend the statement of case. Your Honour has that application behind divider 16.
Yes.
And page 135 of the bundle is the application notice itself, together with a draft order. Hopefully, Your Honour has had an opportunity to read the witness statement of Mr. Patel.
Yes.
And so Your Honour sees that the way in which this application comes about is that we said at the very outset of this case that our investigations continue. And we reserve the right to add to this case if we discover more. We have discovered more. But through the good offices of this court, by issuing the letter of request, and the assistance of the commercial court in the United Kingdom, we obtained copies of bank statements held at the Cooperative Bank and at NatWest, which made it quite clear that in some respects our particulars of claim were inaccurate. So, for example, the NatWest account, although we inferred it was held or controlled by the defendant, is the bank account of a friend of the defendant.
Right.
And so far as the cooperative account is concerned, once it was possible to trace backwards from the payments into the cooperative account, rather than trying to reconcile the records which the defendant created, it becomes clear that there are a handful of invoices, 4 or 5, where although documents were created, payments weren't made. And it's right to remove those from the statement of case. But at the same time, our investigations have revealed further invoices, and quite a number of further invoices. Those invoices and various emails and payment instructions and the like that have been identified by our auditor, forensic accountant, working together with those within the claimant, were in evidence before this court at the hearing before Sir David Steele on the 15th of September. We have provided a copy of all of the bundles that there have been in this case, in case they become necessary, without the slightest anticipation that Your Honour would actually read all of them. But within one of those, there is a thick exhibit called JP4, which is all of those invoices. But before amending the particulars to deal with payments into Dubai bank accounts, it seemed to us, and my submission it was the right course, that it would be best to wait until we actually had the Dubai bank accounts, because on the 15th of September this court issued a letter of request to the Dubai courts, who have used their good offices to obtain details of the defendant's HSBC accounts held in Dubai, onshore. And so we waited until we had those, so that once again we could work backwards from the actual payments into the account to make sure that we didn't plead payments there. And that is the overwhelming majority of our application.
Yes.
We have identified, I should make it clear, 4 payments which appear to be supported by invoices from the claimant's former legal representatives. We have not sought to add those because we wouldn't like to be accused of expanding the case to add yet further purported suppliers. They may or may not become relevant in due course as part of the evidence, but we don't seek to add them. In a moment I'll take Your Honour through the amendments,
Right.
but we submit that the amendments as regards the invoices and further payments are irresistible, because the invoices have been identified and the bank statements show the money being received by the defendant. We also submit that no prejudice is caused. First, because the defendant's defence to the question of invoices and payment instructions appears to be a blanket denial of any involvement whatsoever. And secondly, because he cannot be heard to complain if these matters are coming to light, because he's refused to cooperate in any meaningful way. Indeed, in December he filed an expert's report from PricewaterhouseCoopers, in which they ask for the very bank statements that we had to obtain letters of request and orders from different jurisdictions to get. So he's chosen to withhold his bank statements from his own expert witness. Your Honour finds the proposed amendments behind divider 18 in the bundle, beginning at page 151. And Your Honour will be able to identify quickly the changes, because they're underlined,
Yes.
and where we seek deletions, we've struck them through. And so Your Honour sees paragraph 12, First Amendment. This is a list of invoices. And really the additions are simply the details of the further invoices that we have discovered. from Lincoln, purportedly from Lincoln Associates, so that we've now identified a total of 31 such invoices. Paragraph 16, as it was originally drafted, was what we had tried to work out as to the payments that we had actually made. Now that we have the defendant's bank statements from Dubai, we are able to say explicitly what payments were made and when. And they begin at page 158. And Your Honour sees a total of 55 payments. I should point out paragraph 13, a small addition. Paragraph currently reads, on each occasion the invoice created by or procured by the defendant was approved for payment by the defendant by affixing a stamp bearing his name. We seek to insert the words or causing to be affixed a stamp bearing his name. We say that it makes no difference whatsoever whether it was the defendant's physical hand or somebody else's physical hand marking that it was the defendant who approved the invoices. And that in fact those stamps accurately record the approval of the invoice. There are some amendments to paragraph 17 which are consequential on the change to the list. This is page 160.
Yes.
And they simply follow because of the change of number. Paragraph 19, as it currently stands, pleads that we infer that 2 HSBC accounts are held by the defendant. Well, that's no longer a matter of inference. It's proven conclusively by the receipt of the documents from the HSBC and is also an admitted fact. The defendant admits that fact in his defence. There are a couple of small amendments to correct typographical errors in paragraphs 22 and 23. And again, paragraphs 26, 28, and 29.
Yes.
And again, 31, 32. Perhaps if I pass over the typographical errors and move to the next substantive amendment. The next substantive amendment, page 166. Paragraph 45. We have found an additional GPW invoice, and we plead the details of it in paragraph 45. That's the only addition. That then, of course, brings consequential changes. I pass over the typographical matters. Paragraph 51. As currently pleaded, it says the claimant was induced to make payment of the balance of the sums purportedly due under the false invoices. So some payments were made out of solicitor's client account, the rest made by the claimant directly. But we are now able to particularize the precise payments and the dates on which they were made. And that is what paragraph 51 now does. Paragraph 52, again, it's no longer a matter of inference that the cooperative bank account is held by the defendant. It's a proven fact and an admitted fact. Paragraph 60. There are three further invoices, purportedly from counsel. I should say fee notes. Barristers are quite cautious about that for various reasons. So we simply plead the further details of the fee notes that we've identified. paragraph 65, once again, instead of simply making a general statement, we're able to say precisely which payments were made and when. And then in paragraph 71, the value of the claim as a result of the further payments that we've been able to identify increases from 4,190,644 dirhams and 2,250,532 pounds, and there was a $50,000 payment that was missed off that total, to 8,735,340 dirhams, $50,000, and 2,039,793 pounds and 70 pence, reflecting the invoices that we found that weren't paid. And there are no.
The 8,000 dirhams or the US 50 US.
No, it
in
is.
Addition?
It is 8.7 million dirhams of payments into the HSBC account. $50,000 into the HSBC account, and a little over £2 million into the NatWest and cooperative accounts. There may be a few dirhams either way between the various accounts, a few pounds and a few dollars. So we submit that all that we are doing is tidying up the pleadings to fit with the available evidence. And the argument, frankly, we submit that the application is irresistible.
Right.
That no possible prejudice could be caused to the defendant. One thing to bring to Your Honour's attention immediately, in paragraph 2 of the defence which he filed on the 23rd of December, the defendant reserves to himself permission to amend his defence in due course.
Yes.
So he on his own case has yet to particularise his defence fully. So he can't possibly be prejudiced if he's asked to account for further invoices and further payments.
All right.
Do you want to excuse my back for 1 moment? Unless I can assist, Your Honour. That's what I say about the amendment of this one.
Thank you very much. Defendant, would you first go through what we've been discussing regarding the timetable and the rest of it? Then we can move to the application.
Yes, Your Honour. In terms of the timetable, Your Honour, I'd like to mention the fact that I have reviewed fully the order that you provided, the draft order that you've provided. In terms of the order itself and the contents therein, we don't think it is realistic, as my learned friend had said, to list the dates up till trial. The reason being that, as you are fully aware, our client remains incarcerated at this present moment in time, and we have very little access to him. And if I can just make that point and labour on that point a bit more, as my learned friend had said that I would be doing, we have access to our client on a Wednesday and a Thursday morning to the visiting hours for lawyers at the Bodabai police station. And on that basis, we are able to go there between 9 a.m. and 12 p.m., but we are not allowed to see him for more than 5 to 10 minutes at a time. And that depends on the guard that is on duty on that particular day. So depending on that, we can either get 5, 10 minutes. Maximum we've ever got is about half an hour, but that was because of the guard. He let us stay for a bit longer. But it all depends. It's very ad hoc, and so for us it's very difficult to get full and proper instructions from our clients on that respect. But in terms of the timetable, specifically in relation to point 2, which is the reply from the defendant, we believe that that is a very tight timetable, 10 days. As I said, we only get to see him twice a week for a very limited period of time. So to put forward a reply within that period, we would be seeking a reasonable sum of time, as my learned friend put it earlier, for us to be able to reply to the application. In terms of the application itself, I would like to mention a few points. You would have received our letter of today's date in the early hours this morning. Do you have a copy to hand, or would you like me to hand one? Oh, great. And we received the claimant's skeleton argument only yesterday evening, just before close of business. And within that claimant's skeleton argument, it raises significant matters such as request for immediate judgment and strikeout, which have just been put before you. As you're aware, our counsel is not in attendance because they're based out of the UK, and the reason why they're not here is because we do not have access to funds to deal with the litigation at this present moment in time. Notwithstanding any argument put before this court today by the claimant, any issues raised does not alter the fact that our client has no funds to further its litigation. The claimant is well aware of this because we have written to them in regards to this. We've written to them, we've actually made an application, but then we decided to withdraw on the basis that we would try and seek consent from them, but this was subsequently refused. As such, we are not able to deal with the application for immediate judgment and or strikeout until funds are actually released so that we can pay our counsel to deal with these matters. So on that basis, what our proposal is that, as you would have seen in our letter, we would like to make an application to vary the freezing order and to release further funds within the next 7 days. And our position, having discussed this very briefly with our client, is that without having a variation application being listed as soon as practically possible to deal with the funding, we cannot deal with the other aspects of this case in terms of the application for strikeout and immediate judgment, because it will require our counsel to review all the documents, prepare responses, and fly out. As my learned friend has said, it would take potentially 2 days. I think that's what they have provided. Is that correct? Yes. So it will require a stay for our counsel as well. So these are expenses that will need to be incurred. Just on that point, in terms of expenses, the claimant has raised issue with the fact that our counsel had actually come out to Dubai for the purposes of our initial our second application to vary, which we withdrew. And the reason why they came out on that basis, and that's why that was different, is because they were looking to seek funds to further litigation so that it could be paid also for their purposes. And in terms of funding, we initially had a tranche of £200,000 which was released, and that was for the purposes, as far as I am aware from the hearing, was for the purposes of preparing the defence and the statement of assets that our client was requested to do. Furthermore, it was also to deal with ongoing criminal proceedings which are running in parallel, and a number of reports that are required for the purposes of the court expert. So there are a number of reports that we've had to obtain from PwC, as well as other forensic reports that we've had to do in terms of the handwriting expert reports, and these were all necessary for the purposes of furthering the criminal proceedings. So in that respect, the funds that we initially received in the sum of £200,000 have now been exhausted, and there are various amounts that are outstanding, not to mention our own firm's fees, but also our counsel's fees, who since their instruction 3 months ago have not been paid for any work that they've done. So we need to, as far as I'm concerned, as far as our client is concerned, there is no way he can fund his litigation. He's being seriously prejudiced by the fact that he has various claims that he would like to pursue. There are various claims that he has had to defend both in Guernsey and in the UK, as well as the DIFC and the criminal proceedings here, and that has exhausted those initial funds, and we now require further funds on that basis.
Right. And in terms of the permission to amend the particular clip?
In terms of the permission to amend, I've discussed this briefly with my learned friend before we commence proceedings today. In brief, we personally do not have any objections to the amendments. that basis, we will ask for some time, an additional time, to actually come back, confirming our client's instructions on that matter. But in principle, we don't have any objections to the amendments, having read the amendments.
Right. So in conclusion, regarding to the draft CMC order, you are sharing the claimant position that at this moment you think this is not appropriate for the court to issue the case management order until after the application for immediate judgment dealt with?
And our application to vary. So we would like to make the application to vary before the application for immediate judgment or strikeout, in order that our counsel can then have funds available to then review that application. So our position is yes for the timetable to be,
right,
I guess, stayed until after those applications are dealt with, so that we have appropriate funding in these proceedings.
So in this case, you would like the same judge should deal with the both applications in the
I
same
think that
day?
would make sense, yes.
Makes sense.
I would envisage on that matter that the judge dealing with the immediate judgment application
Right.
will either grant it, in which case the case is over, or dismiss it, in which case he will presumably turn to our strikeout application, which again he will either grant, in which case the issue is crystallised, or he'll refuse, in which case the issue is crystallised. And at that point he can then proceed to give trial management directions immediately.
Right. So I'm still considering maybe the question for the defendant, if the judge refused the immediate judgment and he give a direction for the timetable for the procedure, then how you will be able to represent your client? Giving that consideration, the instruction limited time you receive from him because he's in the jail, how you will be able to continue presenting?
Sorry, are you speaking about the actual funding of
No,
the case?
has nothing to do with funds. What I'm considering, what you are saying now, the major concern you have is that you don't have enough time to receive instruction from your client.
Correct.
And this is why you cannot confirm the timetable procedure and you want to postpone that. So if the court give an order to continue with this case even after the immediate judgment has dealt with,
Yes.
then how then you will be able to continue receive instruction from your client? So
On the same basis
the
that
same
we are
problem.
on the same basis that we are receiving instructions at this particular moment in time, which is very ad hoc, 2 meetings a week and a few phone calls, and that's pretty much what we have available to us.
yeah, so this is what I'm really consider is not fixing now a timetable wouldn't be changed even if we fix it later on. So the main problem you are facing right now, it will be continue with your client. So this is why
unless he's released from prison, so that's the only
Yes.
position at the moment. Whilst he's in prison, the situation does not change for us.
Yeah.
We have limited access to him, and that continues.
Can I insist, perhaps?
please,
Ryan?
yeah, sure.
We did ask for all of the previous bundles to be before you. Do you have them in court,
No, I have it in a file box here.
in file box?
Yeah.
Because in volume 2 of the application,
I can later on I can go back. Yeah,
Yes.
volume 2.
volume 2 of the application of the defendant for
Right.
hearing on Wednesday 24th of December,
Yes.
I'm reading from the front,
Yes.
page 217.
Mm-hmm.
This is an exhibit to the report from PricewaterhouseCoopers,
Yes.
which I referred to, and I'm going to which my own friend referred. It's an email. It's an email dated the 23rd of November of 2014.
Mm-hmm.
And it's an email to my friend Mr. Sethi, in fact. And it's from the email address anon, A-N-N-O-N, investigations @gmail.com. What it does is forward an email exchange between Mr. Haigh and Desiree Edwards, or at least part of an email exchange. And it relates to the payment of a credit card bill. And in capital letters, the body of the email to Mr. Sethi says, "Me paying work company card as GFH had it." Me. Now, the only possible inference from that, I'm afraid, is that Mr. Haigh has access to electronic documents when it suits his purpose, possibly also hard copy documents when it's looking at some of the documents that are in the exhibit, but also he is able to email his solicitors, his legal representatives, directly, because in November of 2014 he was in prison. So it appears he is able from prison to email his solicitor, because that email is written in the first person.
If I could maybe assist on that point, Your Honour, our client does not have access, as my learned friend has mentioned, that particular point, and that is how we receive various instructions, is from a third party that has dictated. David dictates these emails and instructions over the phone, and these are then sent to us, and they are sent in the first person. We have various other examples of that, and so these, yes, absolutely, and the point being that these are not documents that David has access to. These are held on a server outside of this jurisdiction. We have not got access to these documents. They are sent to us for the purposes of furthering the litigation, and what are anything that is in relation to a particular aspect that would assist. These emails are then sent to us. We then take a printout and leave it with our client in prison to deal with. He then dictates a response, and those responses are then sent to us. The third party that has access to these accounts has access to this email account and various email accounts of our client, which we are then forwarded emails from. So just to clarify on that position. Thank you.
Right.
Well, it seems that there's access to a draft of documents on a server somewhere. Maybe something to take up with the defendant's representatives hereafter. So far as his ability to access legal representation is concerned, it's right that I bring to Your Honour's attention a document in the CMC bundle, added late. It's behind divider 14.
Yes.
Page 130. This is a press release issued by the defendant's PR agents. It relates to a purported claim against my clients by a company named Sport Capital BVI. It may be said in passing, in fact, this claim suggests that Sport Capital BVI is out of pocket for an inability to make an investment about which the defendant claims in these proceedings he is entitled to a commission, and complains about another investment that should never have been made on which the defendant claims to have been entitled to a commission. But what it shows is that he's able to launch £33 million claims in London against my client, supported by legal representatives. But he's not able to engage properly with these proceedings. He's also launched a claim in this jurisdiction arising out of an alleged share entitlement. And he's launched another claim in the United Kingdom alleging deceit and personal injury and various other matters against my clients and various individuals within them. So he's quite able to access legal assistance when it suits his purpose. And indeed, when his lawyers were here in the abortive application, it transpired from the fee notes that were attached to that application, which are in the volume that Your Honour has, that they arrived in Dubai on the 16th of December of last year. An application was issued on, I think, the 19th of December, said to be extraordinarily urgent and listed for the 24th to be listed on the 24th of December, which it transpired was also the day that their counsel was due to leave the jurisdiction. So we submit that it's necessary to be realistic. There are no doubt some constraints on Mr. Haigh, but they don't appear to be too much of a problem for him when it suits his purpose.
Well, I think what is between our hands right now is to, the first question is whether we're going to fix a CMC order or we're going to adjourn that until we deal with the board application for immediate judgment and to ratify your application for. And in case this court is going to issue a case management order, then I will need both councils to cooperate and fix a timetable to deal with that. And we'll take it from there in terms of we need to postpone any procedures time for another period. From my end, I'm finished with this hearing until both of you want to address this court.
So is your Honor minded to grant the amendment application?
I will issue my order. Still, I need to further investigate and I'll let you know in my order today.
So far as the amendment application is concerned, perhaps I should say this then for your Honor to consider. My friend says that he will need to go to the Burdivide police station, leave the document with Mr. Haigh. In principle, he doesn't object. If your Honour is satisfied, A, that the amendments properly reflect the evidence available and are made for good reason, and B, that it can't cause the defendant any prejudice, then whether the defendant would like it to happen or not is not the issue. Similarly, whether the defendant has an answer immediately is not the issue. He, of course, has the opportunity to amend his defence. And on the question of the cost of the amendment, I would submit that the cost should be costs in the case, in this particular case, because of the state of the pleadings and the history of the case.
All right, thank you. Yes, any...
Your Honour, on the costs, I would say that given the fact that the claimant made the application directly and did not approach us beforehand,
which application?
The application for immediate judgment and strikeout.
The application for immediate judgment or for permit to the change?
Sorry, I beg your pardon. The application for the amendment to the particular claim. I would also humbly request that it be costs in the case at this particular moment in time.
All right, so I need to go through to my office and go through some of those references. If I will not be able to deal with it, to issue my order today, I will be issued maximum by tomorrow. And the registry will let you know about my order.
Yes.
Right? Thank you very much for both.
Of course. So far as the timetable is concerned, can I just say this? It begins on the 26th of March, I believe, with disclosure. Yes, that's the earliest date.
Yes.
Perhaps that is almost 6 or 7 weeks from today. Perhaps Your Honour will be minded to push that, if Your Honour is minded to make an order for the timetable, to push it back to a date 6 or 7 weeks after the date for disposal of the immediate judgment application.
So Shiraz, same?
I wouldn't be against that, but I think, as I said, the application for the immediate judgment, we would need time to consider it properly. And again, our client's instruction is that before any application for immediate judgment is dealt with, we need to deal with our variation of the freezing order so that we can release funds first and be able to deal with the application for immediate judgment thereafter.
Thank you very much for both of you and have a good day. All right.